Hi, everyone. Welcome to today's Tech Contracts Academy LinkedIn live chat about data terms. Before we dive in, some quick housekeeping. This program's planned for about 20 minutes. It's being recorded and will be available on LinkedIn. This conversation is for general educational purposes. While we are both attorneys, this is not legal advice, nor is it legal advertising. Finally, we welcome your questions. Please submit them using the comments tab. With that out of the way, our introductions. I'm Kathy O'Sullivan. I'm here with my colleague, David Tolan. David is the founder of Tech Contracts Academy and the author of the ABA's best-selling Tech Contracts Handbook. Hi, David.
Hi, Kathy. Very nice to be here.
All right. Well, why don't we dive in? We've got some questions. As I said, we welcome your questions also in the comments tab. David, why don't we start out with a threshold question? What kind of contracts raise issues about data? And should contract drafters address data management in every contract?
Yeah, so it's actually really vital to start out with an understanding of where data terms come into tech contracts and why. Data was not a really vital concept in the olden days when the industry was just on-premise software. At least that was the bulk of the deals that you did, maybe on-premise software plus professional services. It's the rise of cloud services, rise of cloud computing that makes data such a big deal. So the answer to the type of contracts is that data is most important, most at issue in software as a service contracts, platform as a service contracts, infrastructure as a service contracts, and other cloud services contracts. And let me just be really clear. By that, I mean that the technology that's at issue in the contract is on the vendor's computers. It's not on-premise software that the vendor gives the customer to put on its own computers. It's on the vendor's computers, or maybe the product in infrastructure as a service basically is the computers. In any case, it's remote access. And the reason it's such a big deal there is because now you have technology that the customer is using in the vendor's hands, not the customer's hands, and the customer's data is running through that technology, maybe even being generated by that technology. Maybe like regular consumers are pouring information into the customer's services when they interact with the customer through some software as a service system. So all this data that's vital to the customer is getting picked up by the vendor and is on the vendor's computers. And that is where you raise all these issues about what data rights are going to be and what data responsibility is going to be. A quick caveat on that, though, before we leave the question. It's not like data terms are irrelevant in other types of deals. So you might have, an on-premise software deal. So all the data is on the customer's own computers. You don't need a ton of language about rights in that data, control of that data, etc. But you might still need some. There might be vendor backdoor access to the customer's computers in order to do maintenance, for instance. And the same thing could happen in a professional services relationship. Maybe there's implementation or customization or something along those lines. In that case, too, you might have a way for the vendor to get in behind the firewall. And so there you have non-trivial concerns about vendors' obligations related to data, but it's nothing compared to the classic cloud services deal, software as a service, et cetera, where the vendor literally holds the data.
So David, in your master classes and your webinars, you've repeatedly said it's not really possible to own data. Can you explain what that means?
Yes. So I do say that over and over again, and in other speaking engagements too. There's a misunderstanding of intellectual property out there, even in the Silicon Valley, where I do a lot of my work and where people should know better. It's this idea that you can own knowledge. In fact, people in the tech industry talk about our intellectual property. all the time. And what they mean by that is usually our knowledge, what we know, our techniques, stuff like that. That's actually not legally intellectual property. Actually, it's done so often that I've wondered, as someone interested in linguistics, whether it's taken on a secondary meaning, and you actually, might eventually have a dictionary definition of intellectual property that does fit. But under the law, that's not IP. You cannot own knowledge. You don't get IP rights in knowledge. And data is mostly knowledge, information. So to say we own our data, isn't that meaningful? You don't have a patent in data. You can't have a patent in data. You need an invention for a patent. You probably do not have a copyright in your data, at least not very meaningful. There's such a thing as a compilation copyright. For those of you who are lawyers, you probably heard of that in the phone book cases in law school. But in general, you can't really own your whole data set because you didn't write it, you didn't create it. It's very generic information. You might have a few things in your data that are subject to copyright, but you don't own a copyright in most cases in the whole data set. Same problem with trade secrets. So trade secrets is another form of intellectual property. Your whole data set isn't going to be a trade secret, most likely. It probably doesn't qualify under the legal definition of trade secret. There may be a lot of trade secrets in the data. So all in all, you've got this very large, pile of information, the data in a cloud services agreement. And to say you own it doesn't really do anything. And what I mean by that is, even if you both agree that the customer, for instance, owns the data and the vendor doesn't, because there's not a lot of IP in the data, that doesn't really meaningfully restrict the vendor. That agreement doesn't mean that the vendor can't reproduce the data or share the data or mine the data for good customers to contact. And so that's what I mean. It's not very meaningful under intellectual property law to talk about ownership of data. And what I say in our classes, and we just, we're doing our series of master classes on tech contracts this month and next month, and we just went through this. You do want to say we own the data. There's no harm in doing it, and there is some value in doing it, having both sides agree to who is the owner. But you don't want to rely on that. You want to go beyond saying who owns the data and put in terms about control. You want to say, in addition to, for instance, customer owns the data, if that's the deal, vendor shall do the following and shall not do the following with the data. And there you get a whole lengthy data management and security clause, and which, incidentally, if you want an example of that, all the language from my book, the Tech Contracts Handbook, is online for free. So, best if you buy the book, but you can also just get the language at techcontracts.com and copy it. And there's a whole lengthy set of data security and data management clauses. That's where you get your real bang for your buck in terms of management of data through the contract. It's say you own it if that's appropriate. And actually, there's some other language at the site recommended to help bolster the weak IP rights you get. But then move on and make sure you really address control of the data.
So that's a great segue to our next topic, which are data processing agreements. Customers ask for them, vendors insist on them. What are they, and what should folks be doing with them?
Yes. So the data processing addendum. The data processing addendum is sort of it's a term that has become a bit overused to the point where no one's quite sure what it refers to. It's sort of classically the set of data terms that you need under a contract that's governed by GDPR, by the European General Data Protection Regulation. And you take all the data terms and at least, there's no reason you have to do it in a separate document, but people tend to put them in a separate document, and they call that a DPA, a data processing addendum. The general practice of doing that has led to this idea that a data processing addendum a DPA is what you always need for terms about data. It's perfectly fine to do that, but be aware that can mean a lot of different things. You might have a deal that's not governed by GDPR, and you can decide, do you want to take all your data terms and put them in the main body of the contract, or put them in an addendum called data processing addendum? What I think is important to do and to understand is that your contract very likely needs terms governing data, and you have some choices about where you put them. Don't get sort of distracted by data processing addendum as some kind of magical thing. Put them where you want. It can be in the main body of the agreement. Customers a lot of time make the mistake of saying, well, there's a DPA, so data is fine. They've got a DPA, we need a DPA. A lot of customers and deals we've worked on where we represent the vendor just sort of, they want to make sure we got your DPA, and then they don't read it. It's just contract terms. Something we recommend that you do, and it's recommended in my book, and I teach it in our classes, is take your data terms that are specifically responsive to one statute or another, and put them in a separate attachment, whether you have a separate DPA or not. I generally don't. I generally like to put the data terms in like section 7, they're in the contract, but then the GDPR specific terms are in a separate attachment, maybe called a DPA. The HIPAA terms are in a special attachment. That's a business associate agreement. Maybe I've got other statutorily required terms like under the CCPA, the California statute. I like to put them in a separate attachment because of what I'm going to do with them, which is I'm going to say the terms in that attachment only apply to the extent we have the data and only apply to the data regulated by that statute. And for the vendor particularly, that's a way to segregate out your obligations and not get dragged into all kinds of obligations required by one statute, and then apply them to all of the data. You don't want to be on the hook and be in breach of contract if you fail to do this, that, and the other thing required by GDPR relative to data that's not governed by GDPR. So the idea of separating out some kind of attachment, whether you call it a DPA or not, is a good organizational way to do that. And then just make sure your contract terms say the attachment B, the DPA applies only to the extent that the following statutes govern the data, something along those lines. And again, we have sample language for that. Also might be a good point to stop here briefly and talk about the contents, things you want to look for in the DPA. Obviously, that's a whole course, but Kathy happens to be an expert at that stuff. So Kathy, turning it back to you, what should be in DPAs, at least at a general level?
Yeah, I mean, obviously we can only skim the surface of this, but I do have a few real high level sort of practice tips of a few buckets of items to look for when you're doing your initial review, because chances are you're not going to have the perfect world of what David just described of, the master contract you want and the structure you want. There's a very good chance that you're going to be in a position where someone's going to send that DPA of theirs across your desk, and you're just going to need to deal with it. So my first practice tip would be look in the definition section at the very beginning. There's going to be some definition of something like data protection laws. Skim that quick to get a sense of what jurisdiction or jurisdictions is intended to be covered by it. You may assume it's just the GDPR that was sort of the genesis of a lot of these. At this point, it may be that. It may be a definition that covers any privacy law kind of anywhere. So take a look there to see what jurisdictions are purported to be covered by it. Related to that, think about, and this is a big topic you could spend a lot of time on, is that scope relevant to you? Let's say it is one that's specific to GDPR. You may have very strong feelings about whether or not that is relevant to you at all. There is extraterritorial jurisdiction for GDPR, but it does depend what you do. You also need to think about whatever scope it's saying, is that covering what you need? If you're looking at a DPA that someone else prepared, it may not cover the things that you need or this deal needs. Next, I would say, and again,
that's the particular mistake made by a lot of customers. They say, well, there's a DPA, so we're good. Did you read it? Does it cover what you need? Anyway, sorry to interrupt.
No, that's fine. And also don't assume you know what's in there, because it becomes a convenient dumping ground sometimes for people to put things in that you don't want. There are things that are required, say, by the GDPR. You would need, say, you might need the standard contractual clauses there, but you will often find things that you would be surprised are in them. So just last, since we're just doing a real high level skim here, is what topics are covered in there that are also covered in, say, the main body of the agreement or other exhibits, which is going to take precedence? Do you have an order of precedence in your contract, and which is going to control in the event there's a conflict? Because there's a very good chance there is going to be a conflict. It's pretty rare to see the same topic addressed exactly the same in multiple documents, even coming from the same company, because there may have been different teams writing them at some point, or one is out of date and one's not. Can you harmonize them? Can you eliminate some of them? And nothing else, know which one is going to control if they conflict. And that's just a very high level, like you just got it and you want to take a really quick look at how bad is this? Well, how much time do I need to spend starting with this DPA?
Perfect. Thank you.
All right. So our next question is about the deconversion of data. What is it, and should IT contracts address it?
Yes, the answer is very often you need to address it, particularly if you're the customer. If you're the vendor, you should think about it too, because deconversion could be a service you can make money on. And even if, and you want to protect yourself also against deconversion obligations, which could create all kinds of problems for you. So deconversion is basically translation of data. When the customer's data is running through the vendor's system, it's usually essentially in a language that the vendor can make use of. The data is in a format that talks to the vendor's software, like in a software as a service type deal. And if the customer were to get the data back from the vendor, it might not be able to use it. It might only be able to access this data in any meaningful sense within the vendor's system. And when the relationship ends, the customer needs that data back. And this is something you really got to think about. How do we get the information back from the vendor? And so deconversion is that process. It's the process of transforming the data into some other format that the customer can actually use. You don't necessarily know at the beginning of the deal what that format's going to be. You might, and I always ask the IT people, if I'm representing the customer, what would you need? Can we agree on this in advance? And sometimes you can, but other times you just got to agree that the vendor will provide this deconversion service. And this actually raises some challenges. You got to, everybody's friendly and happy when you're negotiating the agreement, hopefully. But when the relationship is ending, there might be something wrong between the parties. And so the customer really needs to think about that. We're just going to rely on this to all work out. What if the relationship ends with you in dispute with the vendor, but you need the vendor's services? You need the vendor to help you translate that data. And the vendor maybe is claiming that you owe money that you say you don't. So you've got a dispute on your hands. Sometimes we take a termination and deconversion clause and we basically say, even if one party claims the other is in breach, even if the vendor claims the customer is in breach of contract, this deconversion is still required. This is a non-negotiable, non-escapable obligation. But to protect the vendor, we say, provided the customer prepays for the deconversion services. A lot of times the vendor will need some kind of fee to go to the effort of deconverting. So what this does is basically say, we might be in a fight about fees owed, but vendor, you don't have to worry about doing more work for a deadbeat customer. Your deconversion obligation is contingent on them at least paying that. You might fight it out over other fees you disagree about, but they're going to prepay that. And customer, you're not going to be essentially held for ransom. You can get that data back and you can get it converted by the experts into a format that you can use it. So, this is another area where a lot of customers, they look for their deconversion and termination provisions, but they don't think about them. Make sure it addresses that issue of what if the relationship ends badly? That is vital. And I think we have time. We don't have to stop exactly on time. Why don't we do one more question? We can run a little over if we need to.
Sure. Well, speaking of things ending badly, tech vendors are really loath to give data incident indemnities. Why? And why is it so difficult to get a vendor to agree to indemnify you if there's a data incident?
Yes, data incident indemnities are the source of a lot of dispute in some tech contracts, and a lot of deals get done without any indemnity for data incident. Contrast the data incident indemnity with the IP indemnity. Usually, not universally, the vendor will indemnify the customer against third-party claims of IP infringement. But then you run into resistance about doing the same thing for third-party claims of data breach. And it's because the data breach creates problems for the vendor far beyond what's typical of the technology of the intellectual property indemnity. So let me just back up a little and explain what's at stake. So again, the issue is that the customer's data is on the vendor's computers. And the worry is that because the vendor doesn't do a great job with security, a third party gets in and there's a data incident. And now the customer is sued by its customers, its employees, consumers, whoever was the subject of that data, because of something the vendor did. And so the vendor wants intellectual property. The vendor wants an indemnity. There's a logic to it, but the vendor faces a problem that doesn't really come up in IP indemnities, which is that the data incident could be caused by the customer. It's not really an issue in IP indemnities. You're both sort of on the same side in an IP litigation. It doesn't matter whether the vendor is guilty or not of patent infringement. It's going to defend the case, whether the case is valid or not. But here, the vendor really knows that it could get dragged into litigation about a data incident because of something that the customer did. So you get a much more limited indemnity. And you would think that would be fine. You have an indemnity that says we're only going to indemnify you to the extent that we, the vendor, caused the data incident. But that doesn't necessarily work. All of your hard work in crafting a clause that says that might be for naught, or at least for less than you think. And it's because of something that I call the duty to defend law. A lot of states, a lot of jurisdictions have a legal requirement that so long as there's a dispute about the facts surrounding an indemnity, the indemnitor has to defend the case until that dispute is resolved. So if the vendor denies that it caused the data incident, maybe it accuses the customer, and the customer accuses it, it's still defending the customer. They are essentially in litigation against each other in this case brought by the third party, but the vendor has an obligation under the indemnity to defend the customer. And it's very hard to escape that obligation. And you might think, oh, well, you just ask the court to rule on who caused the data incident. That's not likely to be a simple question. That's going to come probably at the end of the litigation. So the concern for vendors who really understand indemnities, and they're hard, is that they're going to be dragged into defending the customer even while they accuse each other of wrongdoing. In fact, they're probably going to have to hire two law firms, one to represent the vendor and one to represent the customer because they're pursuing such different claims. I call this, by the way, the cause problem. And this is advanced indemnity. This is the most complicated stuff around indemnities, how to handle this. The short answer is that because of that risk, and even for less sophisticated vendors, because they just sense that there's more risk and more at stake and more problems with this type of indemnity, they're often not willing to do it. That's why you run into so much resistance on data breach indemnities. Sometimes the customer gets the indemnity anyway. Sometimes the solution is an indemnity with a limit of liability with some kind of restriction on what the vendor has to spend defending the case. Sometimes the solution is a mutual indemnity. And mutual is a bad word for it. It's basically two indemnities, one from the vendor for claims about data breaches it caused, and one from the customer for claims about data breaches it caused. So if they get into this mess about who's supposed to indemnify whom, at least they have the same problem, and it reduces the risk for the vendor and the chances that they're going to work something out relatively amicably, at least about how they're going to handle this case. So those are a range of solutions. The other possible solution is that there's no data indemnity, and a lot of tech vendors, most tech vendors that are sophisticated, start there. They may or may not, for a good customer, give in and offer an indemnity, but they don't want to offer one. And sometimes you can't get them to offer one when you're on the customer side. The thing customers need to understand about that is that doesn't necessarily mean you have no protection. A lot of times customers say, well, if you don't give us a data indemnity, then you get off scot-free if there's a data breach. Well, that's not true. There very well may be, there probably is a data clause in the agreement like we just talked about. And the vendor may have breached that clause, and it's that breach would trigger a right to damages. You might still have claims against the vendor even though you don't have an indemnity, because an indemnity is just about addressing claims from third parties. It's not about liability between the parties. So don't go down that road of thinking you're getting nothing if you don't get a data breach indemnity. You very well may be getting something. All right, I think that that brings us to the end. Kathy, let me just jump in at the end here and give a plug for our series of master classes. This is a new program that we started this month, but is also running again in November. We're doing classes on this very stuff that we're talking about and a lot more. The master classes cover all the key terms in IT contracts. And it's broken into 4 classes of about 2 hours each. And we're running them again in November, starting on November 3rd. It's all virtual. And so you can sign up at our website. Each class gets a certificate, and you get a certificate for doing all 4. So that's available to you to go into much more depth about the stuff that we're talking about and many other terms. It looks like 2 we have. We can stay on. We're almost at a half hour, but we have a question. Let me read it and see if we can answer it right here at the end. Any views on penetration tests? Is it part of the vendor's liability, though contracts don't spell it out? Now that we are on the topic of data incidents, so penetration tests. Yes, I have views on penetration tests. So a penetration test, for anybody who doesn't know, is the customer or maybe the customer's contractor actually hacking into the vendor's systems. Sometimes you do see the right in the clause, in the data management and security clause, to do a penetration test. You actually authorize the customer to do this hacking job. And it's because the customer wants to test the security of its own data. Vendors really don't like this. So a lot of vendors will just say, absolutely no, this creates all kinds of problems for us. If you are the vendor and you agree to penetration tests, obviously you want to limit what you've agreed to. The contract has to be really clear that you're talking about tests that will not intrude upon the data of any other customers, so that they can do a attempt to hack into their own data, and that may raise some technical issues, but that's got to be the contract obligation, or you're going to get yourself in trouble with your other customers and maybe even under privacy and security law. The other thing to just be aware of and answer the question is, if you can't get a penetration test, which often you can't, there's other ways to test data security, and in particular there's the SSAE 18 SOC 2 audits. You get a third-party audit to bring in an expert who's probably much more expert than you are, customer, to determine whether you've got reasonable data security. And that I recommend very much to customers, at least where the vendor is doing it and is willing to do it and will pay to do it. It provides a level of comfort and a level of certainty about data security that you really can't get anywhere else unless you're quite expert yourself. All right, that brings us to the end. Thank you very much, Kathy. And thank you everybody for joining us. We will be doing more of these LinkedIn Live talks, so watch out for that. You can subscribe to our LinkedIn page, the Tech Contracts Academy page. And again, please be aware of our masterclasses and other resources at techcontracts.com. Thank you all.
Thank you. Bye.
If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.